Yes.
My lords, my lady, I approach the end of my submissions. I have one more set of points on the ICJ judgment, and then two very short points before I will hand over to Mr. Dunning to open the second appeal. Shortly before the adjournment, my Lord Justice Males inquired why one would rely on the decision of the International Court of Justice in Azerbaijan and Armenia in the context of this case.
Somebody wanted you to summarise the propositions you drew from it, which
I
you've done.
gave the court two propositions, and I would like now to add a third, if I may. It may be helpful in that context to bring up paragraph 45 in the court's judgment. That is in volume 6, LA 29. I believe it's at page 21. And the opus bundle.
Yes.
And the third point that I wanted to mention in response to that question emerges from that paragraph. And just to refresh, the court considers that, subject to any reservation or express indication to the contrary, the temporal scope of the court's jurisdiction under a compromissory clause is determined by the scope of the temporal application of the substantive provisions of a treaty. Now, what is essentially being said there is that because no substantive obligation applies in the relevant period of time for the circumstances in that case, the compromissory clause doesn't cover disputes when there are no applicable substantive obligations. And that's the third point that I draw from this case, my lord. And indeed, I suggest that it is very much the same here. Once one disposes of an investment, there is no substantive obligation that applies from that point on. And in those circumstances, when no substantive obligation in the BIT applies after the disposal of the investment, the arbitration clause, which is the analogue to the compromissory clause before the ICJ, likewise doesn't cover disputes in relation to those substantive obligations. So in those circumstances, both for the two reasons I gave before lunch, that the ICJ judgment dislodges Mr. Justice Foxton's interpretation point at paragraph 146, and also confirms the jurisdictional character of the obligation. And also for the third reason I've just set out, we say that the decision of the ICJ in Azerbaijan and Armenia is persuasive authority on the point. And in many ways that is unsurprising. As I indicated in discussion with my Lady Justice Andrews, the starting point in international law is that a state has not consented to international jurisdiction. And in order to ascertain whether consent has been given, one needs to look at the compromissory clause or the arbitration agreement as is relevant in a given treaty. In the ICJ judgment, the court there was looking at the scope of the consent that was given by the states parties to the CERD, the convention that applied in that case. And here, it's important to remember, when looking at a BIT, that the scope of the offer to consent to arbitration is likewise an agreement between two states. It's often a point that is forgotten when, obviously, an arbitration under this treaty is almost always between an investor and a state. But when one is looking at the articulation of principles, including in paragraph 45 of the ICJ's judgment, it's important to bear in mind that both the ICJ and a tribunal under an investment treaty are still interpreting an agreement between states. So in those circumstances, the points that I've made, the 3 points why we suggest that this decision is persuasive and relevant to the court, does bind even more tightly when one recalls that ultimately it's an interpretation of an agreement between states.
The principle in the ICJ case was essentially one of reciprocity, wasn't it? That whichever state it was entered into the convention first was accepting obligations, but only with respect to states who accepted the same obligations.
I think that's a fair summary, my lord. And of course, reciprocity is an absolute anchor principle when it comes to agreements in international law. One should not forget that reciprocity is an anchor principle in investment treaty as well. In the same way that I've been submitting that the Czech Republic, as a consent to arbitrate in the treaty, which is delimited by the phrase investments by investors, that is also true of Switzerland in this treaty. The same points about the delimitation of the consent to arbitrate that the Czech Republic makes is also applicable as a form of reciprocity to the other state party to this treaty. So it's an important point, my lord, and it rather confirms that when one starts from the position of there being no consent at all and is looking to reach a balanced interpretation of the extent of the offer to arbitrate that has been given, one would look carefully at the language in Article 9 and Article 2 to ensure that both states have consented to the particular arbitration in issue. And that's why on the substance of the objection, the Czech Republic says that there is no consent to arbitrate for that objection. But of course, at the risk of sounding like a broken record, the only point that is needed to determine this appeal is that that is clearly a jurisdictional objection in the Section 30 sense. And the terms of the treaty, the investor state cases, and indeed the ICJ judgment that we have gone to confirms that last point. While I am talking about Article 9 of the treaty, I may just address a point that emerged in discussion this morning, which the court may well have perfectly in mind, and so I can take it very quickly. Article 9, of course, contains the language in respect of the offer to arbitrate of disputes with respect to investments. Now, over the course of the past day and a half or so, there has been a degree of focus on the element of investor in the treaty, including in Article 1. And in some ways that may be borne slightly of the order in which the appeals were taken. But I just want to ensure that I've made my point clear that the core of the post-dating jurisdictional objection, if I can use that summary, is that if you don't have an investment at the time of the alleged breaches, then there is no jurisdiction. So the phrase is investment by an investor. Both terms are of course used in Article 2.1 and throughout the treaty. But it just occurred to me over the adjournment that ensuring that that clarity is communicated to the court in relation to the focus of the post-dating appeal might be a worthwhile clarification. My lords, my lady, that is what I wish to say following the Azerbaijan and Armenia judgment that we've been looking at. I move to the first of the two sundry points before I draw my own stumps. Over the course of the discussion this morning, there was a suggestion that it would be very unusual for issues of jurisdiction to have questions of fact or merits, or at least determined merits involved. I engaged with the court's questions on that this morning and entirely reiterate those. But I do just want to elaborate briefly, because in international law and international law proceedings, it is not right to say that there is typically and always a first and early determination of jurisdiction as a separate matter, and then a separate and later determination of merits. Indeed, to the contrary, it is quite common that both jurisdiction and merits will be heard and decided following the same hearing. Bifurcation is very often requested in the context of investment arbitrations, and a good deal of the time, a certain percentage of the time, it is then rejected and the tribunal moves on to hear both points together, and that is essentially a function of case management. What doesn't change in that process, however, is the characterization of the objection that is ultimately taken, whether in a bifurcated proceeding or a unitary hearing of both jurisdiction and merits. An obvious point, perhaps, but I did just want to flag that following our discussion, that in the practice of investment arbitration, there is often a commingling together in a single hearing of both categories of fault. My last point, before I hand over to Mr. Dunning, follows my Lord Justice Popplewell's question at pages 173 to 174 of the transcript yesterday. My Lord asked for references to the award where it described the respective investments of the different claimants, arbitral claimants, Conoco, as Diag Human was then known, and Mr. Stava. Just for your reference, my Lord, it's at paragraphs 387 to 394 of the award, supplemental bundle, tab 23, page 120. I don't think we need to go there and go through it now. It's quite clearly set out. This is Conoco's investment, this is what Mr. Stava's shares were, and so on. But you will see that the tribunal does go through and say, this is what Conoco did, signed the cooperation agreements with the local hospitals. This is Mr. Stava's shareholding, and it breaks it down in that fashion. So I hope that's a helpful reference for your lordship. My lords, my lady, unless there's anything further, that's the opening of the Czech Republic on the first appeal.
Thank you very much.
I'm grateful.
Yes, Mr. Dunning.
My Lord, this third appeal turns on the proper interpretation and application as a matter of public international law and on the facts found by the judge of Article 11C of the bilateral investment treaty between Switzerland and the Czech Republic, which was made on the 5th of October 1990. We've already been shown that provision. It's SB tab 22, page 2. And as you know, the relevant provision is Article 1.1, and in particular, the requirement for control in subparagraph C. And the particular issue here presents itself in relation to the first respondent, Diag Human SE, which it is common ground did not qualify obviously as an investor under Article 11A because that's natural persons, and didn't qualify as an investor under 11B because it's not a Swiss company and it doesn't have its seat there and it doesn't have real economic activities there. So Diag Human SE is a Liechtenstein company owned and controlled from 2011 onwards, certainly until the arbitration was commenced on the 22nd of December 2017, as the judge held, by a Liechtenstein trust company as the sole trustee and owner of the shares in Diag Human SE. Now, despite the legal position under Liechtenstein law, and I would add, one need only actually read, didn't necessarily need experts to interpret this trust as a matter of English. The deed is in English, and I don't know whether you've looked at it, but we have the judge's findings, and The judge and the arbitrators decided that Diag Human qualified as a Swiss investor under Article 11C on the basis that it was controlled by Mr. Stava within the meaning of the treaty provision, and that he's a Swiss national. Now, I think Mr. Bastin mentioned that is the basis on which we are proceeding on this appeal, because there was not permission to challenge his effective nationality. But as a matter of background, he was born in the Czech Republic and grew up there until he was 18. And he's a Czech national. I think he also has a Canadian nationality. He is a resident in the Turks and Caicos Island, but he has Swiss nationality as well. Now, the relevant part of the judgment starts, we could look at this please, at CB 23, page 47, paragraph 165. And this is the section of the judgment, the third section of the August judgment, which comes on to consider the qualifying investor objection. And the judge says, at paragraph 165, that brings me finally to what has long been the most important and the most difficult issue in this arbitration challenge. Did the placing of the shares in Diag SE in the Corona Trust in June 2011 have the effect that it ceased to be a Swiss company for the purposes of the BIT, and therefore ineligible to accept the standing offer to arbitrate investment disputes contained in Article 9 of the BAT when the request for arbitration was served, and as I told you, that was the 22nd of December 2017. And the judge says that issue ultimately turns on the construction of Article 11C. The judge also explained, and this is relevant, at paragraph 168 on the next page. The context in which he was making his factual findings. He said, for the purposes of this issue, I held that the scope of the objection open to the Czech Republic related to the effect of events occurring in the time period of the objection taken before the tribunal, which related to the transfer of the shares in Diag SE into the Corona Trust in June 2011, up to the end of the pledge arrangements put in place as an element of the law book transaction at the end of 2011. To the extent that some fresh event was relied upon after that date as altering the position, i.e. an argument to the effect that even if Diag SE was still controlled by Mr. Stava in a relevant sense at the end of 2011, this was no longer the case thereafter, I held that this would not constitute the same ground of objection as that taken before the tribunal. For that reason, the arguments before me and the factual findings made relate to the position at the end of December 2011. So putting those two paragraphs together, 165 and 168, the judge held that the relevant date was the date when the arbitration was commenced, 22nd of December 2017, but that he would assess it for the purpose of the objection by reference to the position as at the end of December 2011. And there was a certain amount of debate about whether subsequent events could be referred to for the purpose of showing what the position was before, or as at the 31st of December 2011. And I'll give you the reference to that later. It's something we covered in respect of the first respondent's notice point in our supplemental skeleton in mid-January. Your Lordship will no doubt seen that.
So for the purpose of relevant date for assessing the position, are we to take it that it is at the very end of December 2011 when the price payable under the law book transaction had not been paid, and the shares therefore reverted to Mr. Starver, but went directly to the trust pursuant to the assignment. Is that the situation we're dealing with?
Exactly.
Yeah.
And in that regard, I was very much assisted by Mr. Goodman's submissions, where he laid out the background, and I didn't really disagree with the way that he characterised the fact findings or the facts.
Yes.
So
All right. Well, that's
the answer is
helpful.
yes.
That's helpful to have clarified.
It's a combined effect of the condition subsequent agreement, the purchase, the sale contract itself, the condition subsequent agreement, and the assignment. And the combined effect of them was when the payment wasn't made by the final date, 31st of December 2011, the shares would have reverted to Mr. Starver had it not been for the fact that he'd assigned them into the trust.
Yes. Thank you.
And therefore they were in the trust at the latest from then. And just in case it's relevant, the economic benefit of the shares was in the trust from the outset of the law book transaction, because the assignment also covered the right to receive the purchase price. So if one's using the word economic benefit of the transaction to mean the right to receive the price for the shares, that was immediately assigned to the trustee. And because that was assigned to the trustee as from the 27th of May 2011, that was why the shares were pledged to the trustee as security for the right that the trustee then had to receive the purchase price if it was paid. And to secure that obligation, the trustee had to pledge over the shares. And what's more, the purchaser gave an instruction. This is the sixth one of the six documents comprising the law book transaction, which are all set out in paragraph 3 of Annex 3. That Mr. Starver was to hold the bearer shares for the trustee. So but that's, I'm not really, I don't think I'm disagreeing with anything Mr. Goodman said. I'm just fleshing it out a little bit more.
Yes.
And which parts of the law book transaction, if any, fall to be ignored because they were held to be a sham?
I was going to come to this in a bit more detail if I could a bit later on, but I mean, I'll give you a quick answer.
It does bear on the point we're on at the moment. I'm not sure it makes any difference in the end.
No, I don't think it does. I mean, that's why, but effectively it's the sale aspect, which I think Mr. Goodman calls performative. But what I shall be giving you the references is that did not in any way impinge upon the trust aspect, which was not performative at all. And it has always been, and in these proceedings, common ground that the trust is valid and effective as expressed on its face. And that has never been disputed, and not even disputed by Mr. Starver when I cross-examined him about that. There are passages when he talked about, for example, in his witness evidence, the full ownership went to the trust.
I understand that. I just, at the moment, slightly unsure of how the assets get into the trust if the law book transaction is a sham. But
well, that was, I mean, that's
I'm not suggesting that the case against you is that they didn't, but when and how
they did. It certainly has never been that.
No, I understand. I mean, and that's why I say it may not matter. But
I don't think it matters. I mean, I think I'm not sure that the judge quite went so far as to say it was a sham. I think he said it was never intended to be performed on the proper analysis of what he said.
I see.
He didn't. I don't think he went to say so far as to say it was a sham. I may be corrected, but it was because the reason why it was characterised by Mr. Goodman as performative is that, in a sense, it was never going to be performed. That was the judge's view of it, that he didn't think that price was ever going to be paid, but he didn't necessarily conclude that this was intended to deceive anybody. I don't think the word sham actually appears in his judgment or in his findings. Yeah. there's nowhere said that, the precise analysis may not matter, as your lordship says, but there's nowhere said that the transfer into the trust was not fully valid and effective, and the position was. That was Mr. Starver's own evidence.
And that took place at the end of.
Well, I've always
at the
said at
end
the
of the period.
latest at the end, because I mean, one could argue whether it was the 15th of December when I think the termination letter was sent. But it doesn't matter, because the judge took the relevant time to be, as it were, midnight on the 31st of December 2011, 1st of January 2012. And whenever it happened in the preceding months, it had happened by, or at least at that moment.
It's just, it was called the June 2011.
Yeah, I don't know why it's called June, because these things actually happened in May as well. So it's slightly mysterious, and it's often just to get it in our minds. The trust deed was executed on the 25th of May, and the law book transaction documents were all dated the 27th of May.
You say that as the Czech ministers went to their New Year's Eve party, they were celebrating more than they knew at the time.
Well, there is another point. I mean, I've got some detailed points about why, whatever the judge found in relation to the performative aspect of the sale, or the sale aspect, that does not impinge in any way on the trust aspect. And I'll give you those references and I come to them in my notes, if that's all right. So just to give you the structure, so we've looked at 165, we've looked at 168, and so far as 168 is concerned, that's where the judge described the scope of the permitted objection, and as far as I'm aware, nothing I'm going to say exceeds that permitted scope. And then the structure of the judgment, as you will have seen, is that the judge made the relevant findings of fact and Liechtenstein law in Annex 3, and then he drew conclusions from those findings in paragraph 170 of the judgment, and we have that at the bottom of the screen. He says, I've set out my findings of fact, which include for this purpose my findings of Liechtenstein law in Annex 3. So he had his findings of fact in Annex 3. He's then got some conclusions in paragraph 170. I'm just going through the structure at the moment. And then we go to paragraph 171 over the page. And, sorry, it just starts at the very bottom of that page. And he says, the effect of these factual findings, that is to say, Annex 3 and as concluded in paragraph 170, is that if Article 11C, I just lost it slightly there, if Article 11C of the BIT requires control of a legal entity to arise from legal rights or to derive to some extent from a proprietary interest in that legal entity, which I shall refer to by the shorthand de jure control, then Mr. Starver did not have it. That is the point at which I just want to pause for a moment. We say, and this is our starting position on this appeal, that the judge concluded correctly there that Mr. Starver did not have it. That is to say that following the transfer of the shares into the discretionary Liechtenstein governed Corona Trust in 2011, Mr. Starver no longer had any proprietary interest in the shares, nor did he have a legal right of control over the shares, and hence not over Diag Human SE. And therefore he didn't have, as the judge called it, he did not have de jure control. But where we submit that the learned judge then fell into error was that having held that in paragraph 171, he went on to hold in the following paragraphs two further things. First, he held that de jure control was not a requirement for control within the meaning of 11C, and that was his conclusion at paragraphs 212 to 215. at CB 23, pages 64 to 66. So he held that de jure control was not a requirement. And secondly, having held that it was not a requirement, he then went on to follow a factual approach, and he held at paragraphs 216 to 218 at CB 23, 66 to 68, that on the facts of this case, despite the complete alienation of the shares and the lack of any legal right of control, Mr. Stava exercised sufficient de facto control so as to constitute control by Mr. Stava for the purpose of Article 11C of the BIT. And we appeal, and we have a separate ground of appeal in respect of each of those two further conclusions. And we submit, firstly, that having held correctly in paragraph 171 that Mr. Stava did not have de jure control, that the judge was wrong in law to hold in paragraphs 212 to 215 that his conclusion on the absence of de jure control was not determinative of the question of control by Mr. Stava in this context. Or to cast it positively, he should have held that his own conclusion at paragraph 171 was fatal to the case that Diag Human SE is a Swiss investor entitled to invoke the protection of the Swiss Czech BIT, including, of course, the standing offer to arbitrate, because the company was controlled by a Swiss national. And we say that is because the provision in Article 11C, which is, I'm sure you've noticed this, applicable to a company from any country in the world, that such a company from anywhere in the world may be regarded as a Swiss investor if it is controlled by a Swiss national or by a Swiss seated company, we say is properly interpreted as requiring a legal right of control. And that could be, perhaps most normally would be, an absolute majority of the shares, or potentially a relative majority conferring control, or some other legal right which gives voting control over the company. And that is our primary argument, and it's the first ground of appeal. The second ground of appeal is that we submit, in any event, that the learned judge was wrong in law, and I do stress in law, we're not appealing on the facts. He was wrong in law to conclude that there was control of the company by Mr. Stava on the facts of this case as he held them to be. And that's our further alternative argument in paragraph 2 of the grounds of appeal. Now, before I go to a bit more detail on the facts and on the law, there is in fact a common theme to the two grounds of appeal.
Just before you explain that, you when you were explaining your second ground, you emphasised, although the transcript won't pick this up, the words by Mr. Stava.
Yes.
Would you just like to unpack that emphasis?
Yes. Actually, I probably was going to explain it in the next bit.
All right. Well, anyway, if it's coming in.
The point, just to answer your question directly and immediately, what Mr. Stava did was quay an agent acting for and on behalf of the trustee. And therefore, in law, his action should not be characterised as his own action, his own control, because he was simply permitted to hold that position as an agent by the trustee as a matter of law.
Yes, I see.
So the two points are quite closely connected, but one is, as it were, a legal point purely as a matter of what is the requirement. The other is even if you have to, even if factual control might in certain circumstances be sufficient, it doesn't work on the facts of this particular case because Mr. Stava whatever practical control he had was not in his own right, was the way that I put it before the judge repeatedly.
Your skeleton is, I think, framed as an attribution argument, but I wonder whether it's more a question of capacity, really. He's not acting in his own capacity. He's acting as an agent, as you would say, and that's the relevant question.
Yes.
In the same way as an administrator or a director of a company or something
Exactly, that's exactly right. And that was exactly the analogy. I mean, I don't think we used the word attribution at all before the judge. It crept into the skeleton and it might have set some false hairs running. But the point that I made repeatedly in the oral submissions at the trial was that he was not acting in his own right. He was acting as an agent. And it's a legal point, effectively. If you're acting as an agent, that's not, should in law characterize the actions of the agent. It's characterize the actions of the principal. It's quite a simple point. But that's our alternative argument. Our primary argument is that there has to be a legal right. But there is a common theme, as I was about to say, running through the two sides of the case. Because we say that on both parts of the appeal, both grounds of the appeal, there was either the critical error or a critical error made by the judge was to take the view that the substantive domestic private law position was essentially irrelevant to the private international law analysis. And that and as he characterized it, that the underlying private law position was merely a matter of form and not, that's in inverted commas, form and not one of substance in inverted commas on the question of control when it is viewed from the perspective of public international law. So that's we say, an error that permeates both sides of the case. On the first ground, we focus on the requirements for a legal right of control grounded in the applicable domestic private law, which here was Liechtenstein law, which governed the trust and the company. And we say that as a matter of law, here, the question of control has to be decided taking into account that domestic private law, because otherwise, this is a point that was explained by Professor Douglas in his text, which we'll come to. If you don't have recourse to private law concepts of property and company law, there is no legal test of control, which is supplied by PIL itself. Because PIL doesn't normally need to have a law as to what constitutes control of a company. Where you need that is perhaps in a property law context or a company law context, perhaps a tax context. You may need to have. So it's domestic law which has to have a view on what constitutes control. And there's really, I mean, in terms of the public international law, you might say there's a gap. I mean, that's one way that Lord Lloyd Jones talked about the relevance of referring to domestic law. I'll show you that in a minute. On the other hand, the alternative approach that the judge took, and he preferred, which was of looking at practical control untethered from any legal right of control, would be a highly uncertain and unpredictable test, as it would involve every issue of control being decided in a purely ad hoc way, with no clear test, which we say would undermine the object and purpose of the treaty, And what's more, the judge's approach fails to pay heed to the very clear, we say, indication in the protocol to the treaty that a legal right of control is required. And I should be developing all these points. On the second ground of appeal, we focus on why the judge was wrong in law to focus on the practical control by Mr. Starver, which he was permitted to have by the trustee without recognizing and giving legal effect to the legal context of that control under the applicable domestic private law, which was actually common ground between the experts, and as I'll be showing you. And the key feature of that was that Mr. Starver's practical control of the company was not in his own right, but as control as an agent for and on behalf of the trustee, who retained control. That's the words that the experts used in their joint memorandum. In other words, it should not be regarded in law as his control, because under the domestic private law, he was only an agent and subject to the direction of the trustee and to the terms of the trust. Now, just on one point, which I think came up during the course of some of the questions, maybe Lord Justice Mayles was making yesterday. But there is no issue on this part of the case, and there never ever has been an issue on this part of the case, that the question of law on which I'm addressing you is a question of substantive jurisdiction within the definition of that term in the Arbitration Act 1996. So that it was, the respondents never pleaded that the issue arising from 11C, still less did they argue that this issue did not raise a question of substantive jurisdiction within the meaning of the Act. That was simply not an issue between the parties. And the only preliminary issue on this part of the case, which was decided by the March judgment, was whether the Czech Republic's objection based on Article 11C, as against Diag Human SE, was precluded by Section 73, which the judge held it was not. And there's no appeal against that finding. So that's why the judge approached this issue in the first judgment. And I ought to show you this just in light of some of the comparisons that were drawn between the points that I'm arguing and the points that Mr. Bastin is arguing.
Yes.
I can see a question.
Just before we do that, can we just see how these appeals fit together? So if you succeed on your appeal, you knock out the claim by Diag Human,
Yes.
as I understand it.
Yes.
But there is still a claim by Mr. Starver and an award in his favour, which, in order to knock out, Mr. Bastin would have to succeed on his appeal, and then he says the judge would then have to decide the issue
Yes.
in his favour. So subject to that, the award in favour of Mr. Starver would stand, regardless of whatever happens on your appeal. Is that right?
Yes, that is correct. And I would just say on that, the judge was conscious of the fact that he treated the two differently. I'll show you his reasoning for that. I'm just about to show you his reasoning for that. But that is why he made the parties, I say made the parties, he encouraged the parties to give mutual undertakings that they would be bound if the Starver issue went back to him by his findings of ownership and control on the matter I was dealing with, which was the Diag Human part of the case. They would be bound by that on the Mr. Starver part of the case, if and when the matter went back to him. And so there are mutual undertakings, which were much debated, but finally given at the end of the trial, And if you'd like the reference, we can provide the reference to that.
Yeah, no, I think I
But that was, so the judge contemplated exactly what you've put to me, because that's why I'm raising it. He contemplated that that's what would happen, that the appeal that Mr. Bastin has argued might succeed, then the case would come back to him. He didn't want there to be any sort of refighting of the issues of ownership and control insofar as he'd been able to make findings on them. And therefore, there were mutual undertakings.
So if
And
you
that
win on,
doesn't
if you
mean there
win on,
won't be some legal argument when it goes back, but there shouldn't be much, if any, evidence taking required at
so
that
if you
point.
win on both your appeals and then on as it were the follow up to Mr. Bastin's appeal,
Yes,
then you've knocked out the claim entirely.
yes.
If you only win on one of your appeals, whichever one it is, then an award remains in favour of
One of them.
one of them. Yes, I see.
Yes, I think I'm past a note, those behind me. But if Diag succeeds, that does affect the quantum of the claim against Mr. Stava. I mean, one thing you may not be aware of, but then that's in the appellant's notice, which is at CB tab 16, page 13, is that there is an ongoing part of the arbitration in relation to quantum, which I'm not involved in, but if you need to know more about that, Mr. Bastin can inform you
Yes.
about that. There's been a remission
Yes.
in part.
Okay. Well, we probably don't need the detail of that for the moment, anyway.
Um,
But
so-
okay, that's helpful just to clarify things for me.
So, what I was explaining, because the question of the proper interpretation, the objection based on lack of control under 11C was always regarded by the parties as a question of substantive jurisdiction. And there was never any debate about that. The judge dealt with it relatively briefly, but I will show you what he said about it in the first judgment. And we should look at CB tab 12, page 52. The relevant part of the judgment starts at paragraph 148, and I think you have been shown this part. And there was, this is the part of the judgment where the judge made reference to, for example, the Daimler case in paragraph 150, and quite a bit of other case law. But all I need to show you is paragraph 153. So the judge has outlined the possible arguments, but he says, and this is really sort of mirroring what the approach that Mr. Bastin has pressed upon you. He says, in any event, the issue for me is not whether a loss of Swiss nationality before the offer to arbitrate is invoked precludes recovery, but whether any rule of this kind is jurisdictional. I'm satisfied that it would be. It involves an argument by the Czech Republic that the offer to arbitrate is only capable of acceptance by investors meeting the nationality requirement at the time the offer is accepted, here the 22nd of December 2017. Whether that contention is right or wrong, it is jurisdictional in character. So he didn't feel he needed to make any findings about the nature of it or the timing of it.
Has he ever answered that question?
Pardon?
Has he ever answered
Well,
that
I'm
question?
coming to that. I'm coming to that because he has effectively, but without it being the contrary to what we submitted ever being argued at the second trial. But can I just take it? Just finish off with this, and then you probably read paragraph 154. So that is how he dealt with it. So this question has always been regarded by the parties and the judge as one of substantive jurisdiction. Now, your lordship asked, I think, on Monday, why should the position between Mr. Stava and Diag be any different, where they both raise so-called jurisdictional issues. Well, you can see the judge's answer, my lord, at paragraph 154. Of course, Mr. Bastin says the judge's answer is wrong, not because it's not jurisdictional in the case of Diag Human SE, because that's never been argued. It's always been accepted that it is. But Mr. Bastin would say that it's wrong, that they should be treated the same, because his conclusion in relation to Mr. Stava is incorrect. Now, and this I'm now coming to, I think, answering insofar as I can, Lord Justice Popplewell's question. So that was the March judgment. We then have 2 or 3 months of preparation. We come to the June hearing. When we came to the June hearing, which resulted in the August judgment, I submitted on behalf of the Czech Republic that the relevant time to ascertain control under Article 11C was the date of commencement of the arbitration, which was the 22nd of December 2017. Now, even though the judge had outlined potential issues with the date of commencement of the arbitration in those paragraphs 150, 151, 52 of the first judgment, the respondents did not contest the position as I submitted it was, namely that the relevant date was, for this part of the case at least, is the date when the arbitration was commenced, which is, in all but perhaps the most arcane cases, the date on which the standing offer to arbitrate is accepted by filing a request for arbitration. Now, as this was not contested by the judge, by the respondents, the judge approached this part of the case on the footing in his second judgment that is the relevant time, and that is, I showed you before, but we'll look at it again. It's page 47 in here at paragraph 165. Oh, I'm sorry, we're looking at the wrong one. Is this, we should have CB tab 23, page 47, it's my fault. So, as I showed you before, but now you can see the context. The judge says that the relevant time is the request for arbitration when the standing offer is accepted. Now that wasn't, that was a result of me submitting that was the position, and the respondent's not gainsaying it.
In fact, the letter we were provided with this morning, the trigger letter, did Mr. Bastin call it, is earlier, is the 13th of April 2017, and is clearly invoking Article 9 because it requests consultations. It doesn't mention arbitration. It may be it doesn't matter because presumably nothing much happened between the 13th of April and the 22nd of December, but as between the two, which is the relevant date and why?
Well, I will defer to Dr. Bastin on that point, if you don't mind. Having written an Oxford thesis and entirely on the subject of investment arbitration, he's better qualified than my LLM from Harvard in international law, I'm afraid. But it doesn't make any practical difference. I'm sorry to be.
It probably doesn't make any practical.
But it doesn't make any practical difference in this case. And I personally wasn't aware of the detail of the trigger letter when we made those submissions at the trial. If we had been, it's possible the judge might have said either the date of the trigger letter or the date of the commencement of the arbitration, but it wouldn't have made any difference.
No, well, I follow that.
But perhaps it makes a difference for Mr. Bastin's arguments, but it doesn't make any difference on this part of the case.
No, well, I'm not sure it does for his either, really, but was just trying to understand the chronology correctly. Anyway,
So
let's move
my
on.
understanding is that was a result of the judge accepting what I said, with the respondents not disputing it. And as far as I'm aware, there was no dispute about that in the respondent's notice or the skeleton argument. And there's certainly not been any. They had to appeal, they haven't got permission to appeal, but they haven't raised it in the respondent's notice. There is a different point in the respondent's notice, which I'll come to in a moment. Now, I hope that, therefore, I mean, what I've shown you, Justice Mills, that is the best I can do in terms of answering the question you posed on Monday, or one of the questions you posed on Monday, is as at what time should this be assessed? And subject to any point about the letter in April 2017, there's no dispute that the relevant date is the 22nd of December 2017, but that is to be determined in this case by reference to the position as at midnight on the 31st of December 2011, 1st of January 2012. For completeness, I should show you how the judge reached that position of deciding that that was the relevant time for the purpose of the objection. And we've addressed this in our supplemental skeleton at paragraph 3, which responded, this is CB tab 21, page 2. And this skeleton is entirely devoted to the 5 respondent notice points. And one of the respondents' notice points was to seek to rely on the 22nd of May 2024 deed of appointment. I'm not going to deal with the merits of that. I'm going to wait to see if this had advanced and how it's advanced in the oral submissions. But what I did, I just wanted to give you the explanation which is set out there in paragraph 3, the bottom of the screen. The judge decided that he should assess the question of controlled as at the 31st of December 2011, 1st of January 2012, following several discussions with counsel during the first few days of the trial, which took place between the 17th of June and the 2nd of July, as to the scope of the relevant issue. And then there are references to day 2, day 3, day 4, and we can go on the next page, 2 sets of references. And the upshot was that events after that cut-off date were not to be treated as relevant in and of themselves, albeit that subsequent events could be available for the purpose of establishing the prior state of controlled or not as at that date. This had the result that a variety of post-1st January 2012 matters on which the Liechtenstein law experts had opined, which were otherwise hotly contested, did not need to be canvassed. So that's the history of how the judge came to say what he did in paragraph 168 of the second judgment. Now, the judge plainly, as I've shown you at paragraph 165, regarded this as an important and difficult point. When he granted permission to appeal, he said, a realistic prospect of success, and it raises a question of wider public importance. And in the form N460, which is at CB tab 25, page 2, he certified there's a point of general principle and importance in the development of substantive law. Now, if I may, my lord, I think it might be convenient if I just outline a few factual features of the case before I set out my legal submissions. But I'm happy to, if you think it's be more helpful to know the main headline points of my submissions first, I'm happy to do it the other way around. But I think if I can deal with these points, as I say, Mr. Goodman laid
in response to your invitation, at some stage, up to you when, I'd like to understand whether, under your first point, you say that legal control is not only necessary but also sufficient, or whether you say it's necessary, but in addition, some element of de facto control is required.
Well, I see that point, my lord, and for purpose of being totally complete, I can understand why your lordship wants to consider that, but it doesn't actually arise on this case because the judge has held that there was no legal control. It doesn't matter for me whether legal control is the exclusive test or just a necessary condition.
So some of the arguments you make would have more force in relation to the former position than the latter,
Yes.
such as, for example, de facto control is messy and difficult to prove.
Yes. My primary case is that you have to have legal control, and that is sufficient, or alternatively, it's not sufficient, it's at least a precondition. But either way, you have to have it. And as the judge said at paragraph 171, Mr. Stava didn't have it. And there are situations, it's not necessarily quite as clear cut as that, because I think I probably concede that there could be a situation. So absolute control, where you have an absolute majority of the shares, that's a simple case. But there are often situations where someone has what is called a relative majority of the shares. In other words, they're the largest single shareholder, but they haven't got 50% in the classic situation. They may, in that situation, it may or may not be relevant to know what the factual position is as regards the other shareholders. That's why I'm just hesitating slightly, but that's not our case.
No,
Our
we'll,
case.
we'll get into exploring what's meant by legal control in due course, but I just wanted to get the shape of the argument, and I think you've given me the answer. Primary case, necessary and sufficient. Alternative case, if that's not right, necessary but not sufficient.
Yeah. And so the judge plainly thought that these were important points of principle, and I just want to outline some of the factual features of the case, which largely agree with what Mr. Goodman said. But there are a few extra points as well to add to that before we get into the legal position. So Diag Human SE was set up as a Liechtenstein company. As a matter of fact, there was never any reason put forward by Mr. Stava could not have established a Swiss company which complied with 11B if he'd wished to gain protection under the Swiss-Czech BIT. If he had set up a Swiss company, and if its seat was in Switzerland, and if it carried on real economic activities in Switzerland, then the company would have qualified under 11B. But Mr. Stava's evidence, and this is, you may say this is not relevant, you may think it is relevant, to just throw this point out. Mr. Stava's evidence at the trial was exactly the same evidence as he gave in the arbitration hearing itself. And I don't think we need to turn it up, but this is day 3, page 11, lines 3 to 24. And the opus reference is SB tab 35, page 4. Mr. Stava's evidence consistently at the trial and in the arbitration was that he was unaware of treaty protection under the BIT until 2017, so long after he set up the company, and indeed long after he'd set up Corona Trust and transferred the shares into the Corona Trust. Now, obviously you appreciate that prior to the 27th of May, Mr. Stava was in effect the sole owner and controller of Diag Human SE. But he by the mechanism that we have already discussed. I won't go back through that. He contributed the shares into the trust, which had been set up 2 days before, on the 25th of May. Now, the Corona Trust was what I call a fully discretionary trust, established by deed on the 25th of May, governed by Liechtenstein law expressly. Trustee was a Liechtenstein trustee company called LNR Trust Reg, which was administered by the partners in a Liechtenstein law firm whose names began respectively with L, N, and R. And the R was Dr. Rabanza, who is a Liechtenstein lawyer who Mr. Stava said was his personal lawyer. And so although the trustee was the company, in a way the trustee was Dr. Rabanza because he was the person who was controlling the company for the purpose of this trust. We have the trust deed in Supplemental Bundle tab 48, though for my purposes, certainly in relation to the trust itself and its provisions, the judge's findings in Annex 3 are largely adequate. But if you do look...
So I'll just go back a step. So who do you say after 2011 did have de jure control? Was it the corporate trustee or was it Mr. Rabanza?
The corporate trustee, but acting through, I mean, obviously it's got to act through a person, and the person was Dr.
That's what I thought you said. You put it the other way around.
Did I? Oh, I misspoke. I'm sorry. If you do look at the deed, you'll find that it was actually made in English. And one can see really just from reading it, even without having the benefit of expert evidence, that ownership and control of the shares is conferred on the trustee. I mean, he had, for example, the power to sell the shares. Now, Mr. Stava was a settlor and the original protector under the trust deed, and the corporate trustee was the sole trustee, and then there was a class of potential beneficiaries. And I do use that term, potential beneficiaries, advisedly. They were Mr. Stava's 3 daughters. They're the ancestors in linear line of the 3 daughters, and their issue and remote issue in linear line. So because it referred to the ancestors in linear line, Mr. Stava was a potential beneficiary, even though he was not named as such in Schedule A to the trust, which is at SB 49, page 1. Now, I think we've dealt with how the shares were contributed to the trust. The evidence of Mr. Stava as to why the trust was established was all through his witness statements. I think there were 4 witness statements where he said that it was for succession planning, and one can see that a variant of that in all his witness statements. But for example, we might just look at his 3rd witness statement in the arbitration, which is SB tab 20, page 4. And there, in the arbitration's 3rd witness statement, he says, as explained previously, on the 25th of May, Credit Trust was established for succession planning purposes. He says, I've always controlled it. Well, that's another matter. But paragraph 13, first sentence, and then he says in paragraph 15, creation of the Credit Trust also served to protect Diag Human from attacks of unscrupulous individuals who were trying to claim a share of the final award. So there seemed to be some sort of third-party asset protection motivation as well. And he also said at the trial, when I asked him questions about this, that the trust was set up on Liechtenstein legal advice, and that the sale, this is coming back to a question you asked me earlier, the sale was a different matter. So he distinguished in his evidence between the sale and the setting up of the trust. And if I could just show you the transcript for day 3, page 11, that's SB 35, SB tab 35, page 4. And so this is a little bit difficult for me to read. Could you zoom out, please? Thank you very much. I'd just like to see page 12 of the transcript in its. So you see at the top of page 12, this is the top right-hand corner on the screen, time when the Corona Trust was executed, the 25th of May 2011, and the mortgage transaction, which is dated 27th of May 2011. That time you had no intention to commence an investment arbitration under the treaty, did you? Yes, in May 2011. No, I didn't. I wasn't even aware of its existence. And that's. It's not. I think I've put a misreference here. Let me come back to this. I may, my lord. That was the reference to the earlier point I was making. We could go on, please, to. If we could go on, please, to day 3, page 36, which is SB tab 35, page 10. If I could see, please, the top of page 36. And I said to him, yeah, so to just the bottom of page 35, the question starting at line 20. In your witness statements, you told us it was done for succession planning purposes 4 times in 4 different witness statements. You mentioned 2 other purposes, hostile third parties and the Czech state. You never said that the trust was set up at the request of the minister. No, I didn't say that the trust was set up at the request of the Ministry of Finance. No. Okay. And then he said, where's it gone? Yes, the trust was set up for my own protection at my lawyer's advice, right? Aram is a different matter. Yes, we can agree on that, I said. So effectively, I'm sorry, I got a little bit distracted with the wrong reference there, but his own evidence was the sale aspect was discussed with the minister, but not the trust aspect. It was a different matter. That was done on the advice of his lawyer. Now, there is a faint suggestion in my learned friend's skeleton argument of paragraph 10 that the transfer into the trust was in some way connected with a conversation with the Czech Minister of Finance. But as I've shown you, that was not what Mr. Stava said in his evidence. And it wasn't actually argued at the trial that that was the case. And that Mr. Stava's evidence was that the purported sale transaction and the transfer of the shares into trust were not connected in that way. Now,
Is there a difference between the two? I thought the transfer took place pursuant to the sale transaction.
Well, it did, but the minister never saw any of these documents. I mean, he didn't know. I mean, he just knew there was, according to Mr. Sava, the minister knew there was going to be performative sale transaction. He didn't know that as part of that, he never saw the documents, that as part of that,
The shares were going to end up in the trust rather than come back to him.
exactly. I mean, so when the judge's findings about Mr. Stava's evidence are at paragraph 19 of Annex 3, and I don't shy away from those. But and that's where effectively the judge held that there was what Mr. Goodman has called a performative aspect, but it's something short of saying it was a sham. But if you look at that passage, you'll see that the judge doesn't make any finding that the minister saw and knew about documents, the law book transactions, and there was no evidence from anyone that the minister was aware that the law book documents referred to a trust, either from Mr. Stava, who I've shown you some of his evidence, or from anyone else. And in fact, the existence of the trust and its holding of the shares was actually kept secret from the Czech Republic, because in terms of the enforcement of the commercial arbitration law, there were some commercial court proceedings in England. And in those proceedings, Mr. Stava made a witness statement or an affidavit, I think a witness statement, which I cross-examined him about, in which he did not disclose the existence of the Corona Trust at that time. And that was A3, page 28, lines 20 to 31, which is SB tab 35, pages 8 to 9.
That was the application before Miss Justice Eden, was it?
It was connected to that. I think it was a security for costs in relation to those proceedings. And I'm slightly struggling with this screen. Yes, I said, that's right. Right in the bottom of the screen, if you're looking at it now. I said, do you recall in 2013 you made a witness statement in the English commercial court proceedings where there was an application to set aside the recognition of the commercial arbitration order? If we could then go to the next page. Okay, and I asked him to look at it, and you made it in English, yes. And at paragraph 1 you said, I own and control Diag Human SE. You see that? And I pointed out to him that wasn't true because of the trust. But so the point is not so much that he wasn't giving up. It just wasn't. There's no basis for saying that the Czech Republic knew about the trust arrangement at this point in time, or it had been discussed with them. Yes, the performative aspect of the sale, according to the evidence, and the judge made some findings, was something discussed with the minister. But the contribution of the shares in the event that the sale did not proceed into the trust was not something that Mr. Stava said was discussed. He said that was a separate matter done on his lawyer's legal advice for succession planning purposes and asset protection purposes. And he didn't even reveal that when he made this witness statement in court in 2013. So to sum up, just on this aspect, whatever may have been the truth about the purported sale, there was nothing performative about the Corona Trust because it was secret. And the setting up of the Corona Trust and the placing of the shares into the trust was not related to any discussion with the minister. And it was done for Mr. Stava's own private purposes of succession planning, as he called it, and asset protection, which is one way of describing his other secondary motive. And that is why it was always, throughout the entire trial below in June, common ground that this was a valid trust and fully effective under its governing law. And that is a very important point for the purposes of my argument. And the suggestion, if there is a suggestion from the other side, that there was no reality to the trust, is not one that was made below, and in my respectful submission is not open to them. Another point I just wanted to stress, the reason I've referred to the beneficiaries in Schedule A of the trust deed as potential beneficiaries is because even under English law, in a fully discretionary trust like this, there is no equitable interest, no equitable beneficial interest in any of the members of the class of the discretionary trust. But in Liechtenstein, they don't even have a concept of equitable beneficial. Even in a fixed trust, there is no equitable interest in the beneficiaries. So there are two reasons which come together here. One is that there is no such thing, and this was agreed on the expert evidence, as an equitable or beneficial ownership in a beneficiary under any sort of trust under Liechtenstein law. But in any event, the experts also said that under a discretionary trust, just as under English law, you don't have any right to collapse the trust, for example. We have the case of Saunders and Vautier, which in a more conventional trust, which you might call a fixed interest trust, something like that, means that the beneficiaries can call for the trust to be collapsed and have the assets distributed to them. But that is first of all not part of Liechtenstein law, and it couldn't be part of Liechtenstein law because they don't have equitable beneficial ownership.
But in such a case, would legal control rest with the trustee or with the fixed beneficiary?
Well, that would be a different case, but I would still say it would rest with the trustee for so long as the trust is in place. If there's an application to collapse the trust, I'm invoking Saunders and Vautier, then the position might change. But the question in the current case is whether there was in fact a right of control, actual control, following based on a right. So, but we are a long way away from that case.
No, but I just want to explore how easy
Yeah.
it is to identify de jure control for the purpose of seeing whether it's a useful test. In a case of a company and 100% shareholder, would the company or the shareholder who has control?
Well, there is a putative controller under 11C, and that can either be an individual who qualifies under A, or it can be a company that fails to qualify under B because it isn't a Swiss company.
All right, well, under C, we've got a German company, 100% owned by a Swiss national. Is the ownership of the investment in the German company, so that the German company controls the investment, or is it in the underlying shareholder in the company who is Swiss so as to come within? And that's pretty fundamental to the idea of de jure control.
Yeah, no, the de jure this is the question we're on here is not a question of investment. It's just a question of investor, and to qualify as an investor under 11C, you have to be a company from somewhere else in the world who is controlled by either a Swiss national under A or a company that meets two of the three qualifications under B.
Take a simple.
So in your case,
Take a simple
it would
case.
be the German company whose control that you're looking for, and that
No,
if
I'm looking at who controls the investor in the investment.
Yes, that's what I'm answering.
Yes.
The relevant control would be is the shareholder, and that gives the company, if that shareholder is a Swiss national or for most purposes a Swiss company, that gives the foreign company, which can be from any country in the world, the status of being a Swiss investor under Article 11C.
That I understand. That's what I thought you'd say.
Yeah.
Why is the position not the same for fixed beneficiary under a fixed interest trust? I think you said to me that
Because they don't have a legal, well, you mean in a Saunders and Vautier situation?
Well,
I mean,
at least for Saunders Vautier, a fixed interest actual beneficiary under English law or under any form of law, sole potential beneficiary, no discretion.
well, that might be different. I mean, I don't want to get too much into other authorities on different situations, but there are other cases which do talk about interests under trusts, that's a question of whether you have an investment usually, not whether you control. Our specific question here is there control? And the reason, I mean, there are a number of reasons why we say that must mean legal control. One is it's a clearer and more predictable and certain test, which is consistent with the preamble. Secondly, it's supported by the writings of Professor Douglas and Mr. Smith, which the judge didn't think were very relevant, but I respectfully submit are. And thirdly, perhaps most importantly here, the wording of the treaty itself, but in particular the protocol, which requires proof of such control. And we'll be looking at it in more detail later, but what the protocol says is that if you want to be recognized as an investor, even before you make the investment, you can be required to produce proof of control. And this will be something that's provided to a civil servant or a state official, prove that you control this company. And we say that is a good indication that the test is to be legal control, because the way you would prove that is you produce a share certificate or some other legal document that shows that you have the voting rights which enable you to control the company. But the judge didn't think that this was an important factor. Well, we submit that this was perhaps his largest error, that proof of such control under the protocol argues strongly in favour of a legal
I understand that, and I'm sorry, I didn't mean to draw you into the substantive arguments when you try to deal with the facts, but you did seek to draw a distinction with a fixed interest trust, and that's why I started exploring what the position would be.
Yeah.
I've got your answer.
But even a fixed interest trust under Liechtenstein law, there would be no legal right, no beneficial ownership and no legal right.
So I understand that your position is that under Liechtenstein law, it's just the trustee and that's it.
In terms of legal
Yes.
rights, yes.
Yes.
There's no system of equity. I mean, it's a side issue, but it's a curiosity that Liechtenstein has this concept of trust, but no concept of equitable ownership.
So,
Well,
ownership is not the same as control. We're concerned with control.
We are concerned with control, and now let me just move on. So I think one further point I just wanted to make before we really get into the legal submissions is that Mr. Stava said that he was executing this trust deed and transferring the shares into the trust for succession planning purposes and asset protection purposes. And he obtained the benefit of having that position under Liechtenstein law, that he had entirely alienated the shares into the trust. The trust was the sole owner and person entitled under Liechtenstein law to have exclusive control of the shares at a time when he obviously saw some benefit in having succession planning in place for the benefit of his family. And he obviously saw some benefit in having protection against potentially hostile third-party creditors. So he achieved that benefit. But on the other hand, when it came to wanting to claim that Diag Human SE could claim under the Swiss treaty, which he didn't even know about when he set up the trust and placed the shares into the trust, he wishes to say that he does in fact have the ability to control the company, the very thing that he didn't want to be seen to have, why he set this up for succession planning and asset protection. And there was quite a dialogue between myself and Mr. Sava about these purposes, and I won't take you to all the references. But I said to him, you do it for tax reasons. And his answer was, I don't pay tax. I live in the Turks and Caicos Islands and there's no tax. But then I said to him, but there is another point, isn't there? That there is mandatory heirship under Liechtenstein law, as indeed under Swiss law as well. And under Liechtenstein law, mandatory heirship applies to 50% of your assets on death. And I can give you the transcript references to this later. But it doesn't apply if for 2 years you've alienated your interest and you no longer control those assets. Now, Mr. Sava had the benefit of that, of escaping from mandatory heirship, his succession planning. I mean, he didn't accept it. He agreed with me. He knew all about the mandatory heirship provisions and so on. He agreed with me that that was the position under Liechtenstein law. But he said, well, we don't pay tax. And, we don't pay tax. That's not the motive for doing this. And he gave another reason, wanting to leave all the property to one of the daughters, which is also something that the discretionary trustee could wish to do. So there was that sort of debate. But the point I'm making is that he had in his own mind succession planning and asset protection as the reasons for 100% alienating his interest in these shares. And then 6 years later, when somebody tells him about an investment treaty, he wants to argue that in fact he's had the right, he's been able to control this company all along. Now we say that having the best of both worlds, give it a very colloquial expression, is not consistent with the proper interpretation of Article 11C and appears to be one without precedent. The judge himself described this feature as unappealing, but he then went on to hold that it was irrelevant under the BIT. And I will show you those passages, and I will show you and explain why, when he held that it was irrelevant under the BIT, he was, in my respectful submission, in error. Now, I think just a few more points by way of introduction before I then come to my legal submissions. As Mr. Bastin has said, the fundamental consideration to bear in mind in relation to any bilateral investment treaty is is there reciprocal consent by the two state parties to arbitrate in the circumstances that have occurred? And so ultimately, the question here can be paraphrased by Article 11C. Did the Czech Republic consent in October 1990 to be claimed against in an arbitration by a Liechtenstein company, which was entirely owned by a Liechtenstein corporate trustee under a Liechtenstein fully discretionary trust, on the basis that whilst the former Swiss owner of the company who had placed his shares into the trust no longer had any legal ownership of the company nor any legal right of control, he was nevertheless permitted by the trustee to exercise de facto or practical control on behalf of the trustee. Now, we submit that that question, in the absence of evidence of subsequent state practice, should be answered solely by reference to the position as at 1990. And in this BIT, there's no clear indication that the host state, which could either be the Czech Republic, or if the investment went the other way, Switzerland, consented to arbitrate and to confer investment protection in such a situation where the putative controller has no proprietary or legal rights of control of the putative investor. And I think Mr. Bastin's already made this point, but because the ultimate question is one of what did the state parties consent to, one should not start with any assumption of seeking to find consent. A bilateral investment treaty is, of course, there are now thousands of them, but they are each exceptions to the general rule that a state cannot be sued by a foreigner in respect of sovereign acts. And in our respectful submission, there is no reason to widen the definition of investors in a way that the states did not clearly consent to in advance, particularly bearing in mind that no one is forced to alienate their property in a company and settle that property in an exotic discretionary trust in a place different from where they choose to live. So we respectfully submit that the proper interpretation of the 1990 treaty is that Diag Human was not a protected investor after the shares had been transferred into the Corona Trust, because as the judge correctly held at paragraph 71, Mr. Stava had no property right nor any legal right of control over the company from that point in time. Now, there are 6 main strands of my argument. And if I can give the headlines now, and then I will fill it in afterwards. The first is to look at the correct approach to interpretation, which, for want of a better term, I would describe as a holistic approach.
I'd like to interrupt you, Mr. Dunning, but
yes.
both my screens have now gone blank.
Oh, well, one of mine has as well. Perhaps, yes. Does that the transcript screen?
Both.
Oh, both. Okay.
I mean, it may well be you're not relying on anything at the moment and it won't come up, but certainly the transcript's gone blank.
It's quite a critical moment because I'm just about to give the 6 main arguments.
Exactly, which is why I asked.
Is the transcript still recording?
Yes, it's running on mine.
Oh, it is? Okay.
Is it running on my lawn?
It's running on
Yes.
my own laptop.
Well, look, why don't we just rise for a few minutes and somebody can sort out my lady's screen for her. Let us know when you've done it.
Just to let everyone know the live stream is still on.
Thank you. I've heard on the live stream before people
like no one touched the button for a while, so it's still yeah, you just type it. Sorry.
Oh, all the others.
Well that's fine. His was fine, that's fine. That's all fine.
I should just ask to these profiles, what should happen from one this week.
Sorry, did I hear that there was another one around here that was gone dark as well?
I think it was these front two screens.
He's working on the cord laptop here.
Oh, it is.
In Blue's one, yeah.
Maybe it's just the front motors thing.
That judge's one just went idle, as in this button, like the screen just went idle because no one had touched the button anymore.
So it's basically hopeless. Basically, see if there's anything in
what's the point?
But, let me just see if I can put a document up and she sees it still, actually. 1 second.
Yeah. Rejection. See that? I'm sure some of the stuff that comes across.
Yeah. Did I hear that your screen went blank as well?
No,
Okay,
well, it wasn't showing anything, but it is now. But I didn't know if that was just because.
Oh no, I just took it down because I didn't know if
Exactly.
you were referring to
Yeah,
anything.
yeah.
That was it.
It was just
No,
the
that-
just the EP screen.
Yeah.
But my other one was fine.
Yeah. Okay.
So everyone's okay now.
Yeah.
Thanks.
Question? Yeah.
Oh, it's fixed.
Yeah, just went idle after not being used.
Switch it on, switch it off.
I mean, just touch a key.
Yeah. You might want to mention that. Or maybe
Yeah,
not.
or maybe not.
At some point.
Already.
Is it ready, Graham?
Court rise when able.
Very good, thank you very much.
I think the problem is not enough mice. I should have brought another one.
So I'm going to now present my legal arguments under 6 heads. And the first is the correct approach to treaty interpretation. And the number of points here, but we say that the judge failed to take a properly holistic approach and to come to an interpretation which is that which is mandated by the Convention on the Law of Treaties, which involves coming to an interpretation which is based on good faith, bears in mind the object and purpose of the treaty, and also general principles of law of civilized nations. And if he had done so, he would have paid heed to what he himself recognized was the unappealing nature of the respondent's position of seeking to have the best of both worlds. Secondly, the judge failed to ascribe sufficient weight to one of the important objects and purposes of a treaty such as this, which is to be derived from the preamble, which is to have a predictable and clear test of control so as to enable advanced planning and certainty for both the investor and the host state. And the so-called test of factual control is really no certain and predictable test at all. It is uncertain, vague, and ad hoc. It gives no yardstick against which to plan in advance, either for putative investors or for host states. And it is likely to lead to protracted disputes, just as it has done here. Thirdly, the judge failed to ascribe to the writings of Professor Douglas and Mr. Smith the persuasive weight which they deserve to have ascribed to them. And instead he paid heed to the writing in Professor Schroer's book, which was hardly in point. Professor Douglas in particular explains why the correct approach in principle is to decide the question of control by reference to domestic private law concepts in property and company law. And he explains why the sui generis approach of simply deciding every case on its own factual presentation is vague and uncertain. And that's supported by the reasoning of the eminent tribunal in the ADT and Bolivia case, which I'll be taking you to. Now, Mr. Smith's article looks specifically at Swiss BITs and gives examples of the type of legal control that they require. And as you'll see, and I'll show you, he refers specifically to protocols to the Swiss BITs, which is a specific feature of this case, which doesn't exist in any of the authorities, as far as I'm aware, that are relied upon by the respondents, the protocol. And now, how the learned judge felt that what Professor Douglas and Mr. Smith had to say was not helpful, and the passage in Professor Schroer's book is unclear. Anyway, I shall make the points in detail. But fourth point is, most importantly of all, the judge did not pay heed to the clear indications within the treaty itself that something more than the uncertainty of de facto control is required. In particular, the protocol to the treaty, which, as I've already said, provides for the advance provision of proof of such control, in inverted commas, proof of such control, which implies that the test should be certain and predictable, such that evidence of a right of control can be readily produced. And the other parts of Article 1.1 itself, we say, all point to the need for a simple and predictable test based on the existence or the absence of a legal right of control under the applicable domestic private law. Fifthly, there was one case in what the judge called the investment treaty jurisprudence, which actually dealt with almost the identical factual position as we have in this case, and that was the UCOS case. That the tribunal in that case included none other than the former United States judge and president of the International Court of Justice, Stephen Schwabel, who before becoming a judge was a professor at Harvard Law School and various other things, legal advisor at the State Department, which is equivalent of our legal advisor in the Foreign Office, obviously. They held that in the case of a discretionary trust, in that case governed by Guernsey law, there was no reason to set aside or disregard the legal structure of the trust that had been put in place under Guernsey law, and they rejected taking a factual control approach. There's one other case involving a discretionary trust called Arbitration, and I'll briefly mention that. It's not so clearly in point as the UCOS case, but it does nevertheless provide some assistance. And finally, my sixth argument is that the learned judge gave incorrect and undue weight to other investment treaty awards, wrongly saying that, quote, a majority of them supported his view, which on proper analysis is incorrect. First, as I've pointed out, and I pointed out at the trial, none of those other cases featured a protocol worded in the way that the protocol is worded in the present case. Secondly, none of them relied upon by the respondents featured a discretionary trust, and therefore they didn't present the same issues as we have here. Thirdly, few, if any of them, actually decided the point in issue, namely whether a legal right of control is an essential requirement, in a case where that was actually in dispute and made a difference. And fourthly, almost all of them were concerned with very different factual situations and different treaties. Now, we had a schedule at the trial which summarizes these points. It is SB tab 39. I don't know whether this is something that's come to Lordship's attention or not yet. SB tab 39, please. Now, I don't know if it can be rotated around. Thank you. So this was produced at the trial, went through cases which were cited at that point. On the left, you see the name of the case and the members of the tribunal. Then you see the treaty wording referenced, whether there was a protocol or not, whether there was a trust or not, and a brief summary of the decision. Now, so those are my six main topics, my lord. Along the way, I will address other points. And one in particular is that the judge's argument of form versus substance, form in inverted commas versus substance in inverted commas, which in my respectful submission is a misplaced way of analysing the situation. Now, the order in which I'm going to take the points is not intended to be a hierarchy, but it's intended simply to be an easiest way to lead you through the points.
You said that number 4 was your most important point, which is unusual for an advocate, but I'm sure it works.
Because I don't think I would do that if we were dealing with an English law point, but because there is, as I think you said yourself, my lord, there's not the same level of familiarity with these sort of issues as there would be with an English law point. Sort of
No, that's fine. I was
setting the scene before.
only teasing.
But although there are these multiple factors, There is in truth a single exercise of arriving at the correct interpretation and deciding whether the Czech Republic gave its consent to arbitrate in the situation that existed here, or if indeed Switzerland consented to arbitrate if the facts had been reversed. So let's start then with the approach to interpretation. I obviously make, first of all, a very simple point. Interpreting a treaty is obviously not like construing a commercial contract. And there is the Vienna Convention, which we have in Legal Authorities, tab 30, page 2. And if we could have, please, the Article 31. Yes, it's there. Okay, sorry. It's 31.1 to start with, but the whole of the article is the general rule of interpretation. This is why it's holistic. A treaty shall be interpreted in good faith, as Mr. Baston said this morning, in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. So it's not ordinary meaning shorn of context, it's the ordinary meaning in the context and in the light of its object and purpose. And then there are further rules which I don't need to take you to. Now, there is a text called Gardner, which is exclusively concerned with treaty interpretation, an entire book. We could just have a look at some passages in there. This is LA, the Legal Authorities, tab 107, page 100. I'm sorry, page 10. And I just want to show you, first of all, the conclusion in chapter 5. Article 31.1, I've just shown you, has probably been cited more than any other of the Vienna rules. This may be because cursory attention to the Vienna Convention's provisions might lead some to think this paragraph is the general rule, whereas use of it is only a starting point for interpretation. Underlying its architecture is the relationship between the treaty's terms and the treaty as a whole. An issue may centre on one or more provisions. Any such provision is to be read selecting the ordinary meaning for the words used. But finding the ordinary meaning typically requires making a choice from a range of possible meanings. The immediate and more remote context is the next textual guide to making this choice, with the treaty's object and purpose as a further aid to this phase of an exercise in interpretation. The rest of the general rule, set out in the later paragraphs of the same article, must be taken into account. They're not subordinate or subsidiary provisions, but equally elements of the general rule. Good faith is required throughout the exercise. So that's why I've described it as a holistic approach. But certainly one does not start with saying, what's the ordinary meaning of control, and then build on from that. And good faith permeates the interpretive exercise. Now, if we could turn back, please, to page 3 of this extract. You see that there's a heading, good faith in context and in light of the convention's object and purpose. The immediate context of the term good faith is in the interpretation of the treaty as contrasted with the immediately following elements of Article 31.1, which refer to the treaty's terms, that is, its words, are to be approached. Thus, the term in good faith indicates how the task of interpretation is to be undertaken. This needs to be considered in conjunction with the position of the term, which is A, in the opening phrase of an article headed General Rule of Interpretation, B, in a paragraph which leads on to a broad definition of the context for the purposes of interpretation, and C, in this paragraph, which ends with a reference to the object and purpose. And I wonder if we could just go just a little bit higher up on the page. And 9 lines down from the top, I should have perhaps taken you to this first. There's a sentence that begins, good faith therefore means more than simply bona fides in the sense of absence of mala fides, the rejection of an interpretation resulting in abuse of rights, though of course it includes such absence and rejection. It signifies an element of reasonableness, qualifying the dogmatism that can result from purely verbal analysis. As discussed above, the term is also capable of a sufficiently broad meaning to include the principle of effective interpretation. And then if we could please go to the next page. And we have a paragraph that is 2.4.5, good faith and the principle of effectiveness. And I'd like to just read, could I invite the court to read that to yourselves, right down to the sentence that begins the dual aspect, 6 lines from the bottom. And then if we could go, please, to page 6. And under ordinary meaning, it says, first and foremost, in considering the role of the ordinary meaning to be given to the terms of the treaty, it's necessary to stress that the ordinary meaning is not an element in treaty interpretation to be taken separately where the general rule is being applied to a particular issue involving treaty interpretation. Nor is the first impression as to what is the ordinary meaning of a term anything other than a very fleeting starting point. The ordinary meaning of treaty terms is immediately and intimately linked with context, and then to be taken in conjunction with all the other relevant elements of the Vienna rules. And then just at the bottom of the page, the last sentence, this section is therefore concerned with identifying what the Vienna rules direct to be taken as the starting point, always with the caveat in mind that this is not a complete or independent interpretive process. And then if we could go please to page 8. And at the bottom of this page, it starts, it is precisely because ordinary includes the meaning regular, normal, or customary that such importance must attach to context. For regular, normal, and customary do not in any way indicate that there is necessarily a single meaning, that is the ordinary meaning of a word, as that triple definition of ordinary itself, only one of several definitions, shows. Nevertheless, courts and tribunals often make an attempt at finding a meaning for a term by use of the dictionary, particularly in technical areas, specialist books that define the term in issue. And then I perhaps could invite the court to read the next paragraph, but then stop at the end of that paragraph.
to me that that passage is rather against your primary submission.
Well, I'm being even-handed. And I think if then at that point, could I then take you back, please, to the Vienna Convention, which is LA tab 30, page 3.
Yeah, I don't actually have, I've been able to follow on the screen, but I don't actually have a hard copy of 107. So as you've referred to quite a lot of it, could that be provided in the morning, please?
Yes, that will be done.
Thank you very much.
So if we then go back to the Vienna Convention, and if you look at the top of the page, carrying on with Article 31, you see that there actually I do think we need to just see the bottom of the previous page to get the full meaning of this. Sorry. So it's provision 3, which now appears on the screen on the left side. There should be taken into account together with the context, and then we can put aside for present purposes A and B, and look at C, any relevant rules of international law applicable to the relations between the parties. And that then raises the question, what are the applicable rules of international law? And if we then go to the statute of the International Court of Justice, which is at LA 94, tab 94, page 2, we see that the sources of public international law are set out in Article 38 of the statute of the International Court of Justice. This is the statute of the International Court of Justice, the statute of the Permanent Court under the League of Nations was in very similar terms. So this has been around for over 100 years. The court's function is to decide in accordance with international law such disputes as are submitted to it shall apply, international conventions and so on, international custom as evidence of a general practice accepted as law, and the general principles of law recognized by civilized nations. And then just, you might note in passing that there was no stare decisis or doctrine of strict precedent in international law. But the point is, C there, general principles of law recognized by civilized nations. And on that aspect, we have two things to show you. First of all, an illuminating lecture by Lord Lloyd Jones, which we have at Legal Authorities, LA, tab 110. Which he gave in France, yes, at the Conseil d'État in Paris in 2018. And the topic is general principle of law as a source of international law. Very interesting article, but I won't take you through all of it. So if we could go please to page 3. And he says there at the top of the page, it's important to bear in mind that paragraph C, he's talking about the statute of International Court of Justice that we just looked at, C, is concerned with principles which are different from rules. And he's talked about the process of discovering general principles. Paragraph C is clearly intended to operate at a higher level of generality. not a case of importing into an international or detailed private law rules, nor would it be appropriate to seek to do so. What matters here are the underlying principles which reflect the requirements of justice. He cited law there. We could see the rest of the page, please. I'm not going to read it all out, but your lordships will find this, I think, of some interest and use. And then over the page. He says, it may be that paragraph C, when first adopted, was already the practice of arbitral tribunals. However, the case that since its adoption, other arbitral tribunals are considered to be declaratory of international law. And he gives some examples. And then over the page, please. And then perhaps just conclude with the last paragraph there, which refers back to Mordor. Now, we also have a passage discussing these aspects in the Gardner book that I took you to, Legal Authorities, tab 107, pages 11 to 14. So just to capture where we've got to, the general principles of law of civilized nations, together with the good faith requirement, can be used as the basis for the Czech Republic's arguments that international law does not permit the respondents to have it both ways, and that the substantive legal effect of this discretionary trust under the applicable domestic private law cannot be ignored, or to use the terminology in the UCOS case of Judge Schwabel and others, cannot be placed to one side. Now, the judge noted and recognized the unappealing nature of the arbitration claimant's position. We could just look at the judgment on that. That's CB tab 23, page 64, at paragraph 213. And he says, I accept that limiting Article 11C to control exercised through legal rights would offer a simpler solution. I'll come back to that. And he says also, I accept that it might be said it would be rather unappealing if Mr. Starver, having transferred the shares in Diag SE out of his ownership to achieve some legal or fiscal consequence, could, when it suited him, take the position that those shares were really his. That instinctive reaction is put in characteristically clear terms by the late Edmund King, Queen's Counsel, in his March 2018 lecture, as Pugashov ruling the end of offshore trusts, and should it be? And then you can see what he's quoted from Edmund King's lecture. And over the page, please. I'll set out quite a lot of that. But having recognized the unappealing nature of the arbitration claimant's position and the factors to which Mr. King drew attention there in his lecture, when it came to 2014, paragraph 2014, he said this: however, it's important in this respect to note that the context in which the control issue arises in Article 11C is rather different. And then he goes on, the claims of Diag SE remain the assets of Diag SE. Any recoveries available to creditors and shareholders. Issue which arises a rather different one of whether Diag SE should benefit from the protections afforded by the Swiss Czech Republic BIT because of control by a Swiss national. says this is a context in which I've been persuaded that the word control in Article 11C carries both its ordinary meanings of control and de facto control, such that on appropriate facts, Article 11C will be engaged where the control of the legal entity by nationals of a contracting state falling within 11A and can be established by means other than the exercise of control through legal rights. So what the judge effectively held there is, although this is unappealing to ask to be treated in a way which is contrary to the legal structure that you've set up, he held that that was not really relevant in international law to the proper interpretation of this PIT. And in my respectful submission, the judge fell into error in that regard, because the correct interpretation is not just a question of the ordinary meanings in the dictionary. It is a question of the reasonable, good faith interpretation having regard to all the terms of the BIT, including the protocol and the preamble. And having the best of both worlds does not simply evaporate as a relevant consideration under public international law. It is something that is perfectly possible to be taken into account for the reasons I've explained under the principles of interpretation in the Vienna Convention on the Law of Treaties.
What does the judge mean by saying that the word control in 11C carries both of its ordinary meanings? Is he saying that either will do? You might have legal control, in which case that's good enough, even if you
I think he is, yes.
have de facto control.
I think he is saying that. I think he probably is, because he's saying that the absence of legal control is not fatal, because factual control may suffice in certain circumstances, and this case is one of them. But my main criticism is the judge seems to have thought, well, it's much more like interpreting an English contract. You know, you're just looking for the ordinary meaning, whereas the test, the correct test, as explained in Gardner under the Vienna Convention, is a much broader and more flexible one, which brings in concepts of good faith, reasonableness, and doesn't really turn on the ordinary meaning, other than the meaning in the particular context of this particular treaty, bearing in mind its preamble and its protocol.
Is that the first of your 6 points done?
Well, it's largely done. There are some ancillary points that the judge makes in that context, which I was going to deal with. I just that can be a convenient moment, my lord.
All right, yes, certainly. 10:30 tomorrow.